Last month, I recorded a video about a audit, self-imposed audit I performed on myself and my notary journal. That audit caused me to rethink how I've been keeping my notary journal. And so I went back to some books. And whenever I want to study and learn some more about being a notary after 20 years, I make sure that I include Michael Closen in my research. I've talked about him before, and again, this is not a promotion. I get nothing for mentioning his book, but this is his latest edition, Professor Closen's Notary Best Practices. And he's dedicated an entire chapter of his book, chapter 17, Journal Records, on the topic of the importance of the notary journal. I reviewed his chapter in the first edition of his book. I've got paper clips highlighting in it, and I came up with 14 suggestions or recommendations Michael Closen has for notaries regarding their journal. And I want to share that information with you, especially if you're like me and are commissioned in a state that does not have any notary journal requirements. In fact, did you know that there are fewer states that have notary requirements than don't? Yeah, I was shocked too. I'll talk more about that at the end, but really, all I really want to do in this video is share with you what I learned from a notary expert, Michael Closen, about the importance of keeping a notary journal so that you can decide whether or not it's time for you to elevate your journal keeping as well. Let me share my screen. After reading Professor Closen's chapter called Notary Journal Records, I broke out into 14 categories, the most important things that Professor Closen recommends notaries to document in their journal. So, above the line is what should be in the journal. Below the line, these are simply my comments, my recommendations, and how I'll be journaling going forward. Number one, Closen recommends that we always include the date that we meet with the signer. So always the present or current date that we're meeting with the signer. And I think that goes without saying. I believe most of us who keep journals know how important the date is. Professor Closen feels that we should also include the time that we meet with the signer. I was surprised to see that he recommends not only the starting time of the notarization, but the end time of the notarization. He suggests that with most notarizations, I'm not talking about loan signings specifically, that most notarization should not take a lot of time. Closen states that if we are meeting with the client for hours or extended periods of time, it could be argued that we were doing more than just notarizing someone's signature. He, in fact, mentioned it could appear that notaries were going beyond the scope of our role, for example, practicing law. Now, that surprised me. I never thought about that, but I can see his point. But for me, I'm not ready to start recording the end time of my appointments. I did it a few times after I read this, but I'm noticing it's difficult for me to remember. Number 3, the location. Closing suggests that we record the address, county, state, or any other information that identifies where we met with the signer. I really liked number 3, location. I would occasionally make an entry in my journal indicating if I met the signer at a Starbucks or Panera Bread, what have you, but I never thought about recording um, in a separate place the location or the address or county of the, excuse me, of the notarization. And so I'm rating it a nice to have, not so much a must have or should have. To me, that's going above and beyond, but as a mobile or traveling notary, I do think it would help us to make a note if we met with the signer at their home, at their office, or again at a restaurant or establishment. Number 4, the type of document and the number of pages. Now, I always record the title of the document or the name of the form, but I have not always, or maybe I did it once, recorded the number of pages in the document. According to Closen, that could be helpful, especially if it's a large document. And let's say when you met with them, there were only 50 pages, but at a later date, should you be called to court to testify, and the document is now 100 pages, that would be very helpful to the court. So I agree that we always need to record the name or the title of the document. As far as the number of pages, I would rank that as nice to have. Number 5, notarization type. This is getting into the type of notarial act that you performed. In every state, our laws tell us what we can and cannot do. And so the type of notarial act could be an acknowledgement, jurat, oath of office, signature witnessing, or something else. I agree with Professor Closen that recording the type of notarization is a must-have. We should do it each and every time. Number 6, the signer's information. This is pretty easy to remember to do because there is a space requiring that information. That is where we would print the signer's full name. Well, Professor Closen is recommending we go a little further and make sure we include their address and contact information. I'm okay with that, but I would also recommend that if we're going to do that, it's important to use a type of privacy guard or covering so that the notarization you're doing today, the person that you're meeting with today won't see the home address and name of the individual you met with yesterday. So I'm a must-have, definitely with the signer's name. Number 7, identification. This also should go without saying that you want to document the method you use to identify the signer. Go ahead and call out whether it was a license, a state ID, if you personally knew them. If it's a passport, what was that passport? What country was that passport for? Since Alabama doesn't require that we use a journal, I take the extra step and close and agrees to include perhaps the expiration date of the ID or identifying number like the driver's license number or passport ID. So with items 1 through 7, I'm on board with Professor Closen, pretty much with all 7, except I ended up being a nice to have when it came to location. On item number 8, oath. There are some documents that do require notaries to administer an oath or affirmation. Professor Closen points out it's not enough for you just to list the type of notarization was a jurat or an affidavit, and that implies you gave an oath. Professor Closen recommends that in the journal we make a separate note that states the oath was administered. And those of you who are new and have yet to memorize an oath, Professor Closen recommends that you go ahead and write it or tape it in the inside or backside cover of your journal. It's easily accessible and available to you, and there's no harm in you reading the oath when needed. So again, make a note that yes, you did administer the oath and the type of oath that you administered. Number 9, the signer's willingness. Professor Closen states the assessment performed by the notary to determine the signer's willingness to complete the notarization. This is a critical step in the notarization process. I have not always documented what I did to determine the signer's willingness. Now, I have done it, I would say, whenever I felt there could be a question about it. And I often do it if it is a power of attorney or will. But I like what Closen says about this. And so while I didn't say must have, I agree it should be done. I'm going to start doing it more often. Number 10, competence. This is in line with number 9. Closen suggests that we record the assessment performed to determine the signer's mental competence. And so competence and willingness, that assessment can be done at the same time. I shy away from asking the signer, who is the president? What is today's date? Those are things that can be easily obtained by glancing at one's watch, phone, looking on the wall. I recommend for both of these, 9 and 10, that you have a conversation with the signer, not where you were asking for yes and no responses, simply a conversation. How are you feeling today? Can you tell me a little more about this form that you'd like for me to have you sign and notarize? What's your understanding? Is this something you're comfortable doing at this time? Is anyone forcing you to sign? What do you hope to accomplish? By asking one or two of those questions, you should have enough to ascertain if this person understands what they are signing and if they are doing it willingly. But if you hear a lot of hesitation, um, slow to speak, um, running off on tangents, not answering the questions that you do ask, those are red flags. You should slow the appointment down to give you time to really assess and determine whether you should stop the notarization or not. Number 11, the notary's, the signer's signature. The signer should always sign the journal in your presence. This is non-negotiable. This is the best proof that you will have that you met with the signer at the time of the notarization. Professor Closen recommends that you watch, observe while that signature is being made, and that you compare the signature in the journal with the signature on the ID. Number 12, thumbprint. Wow. This question came up in my Facebook group, Notaries for Alabama Hangout, which is for Alabama residents who want to become Alabama notaries. We had a good discussion about this. Michael Closen recommends that if it's not prohibited by law, it's good practice to ask the signer for a thumbprint. I have always felt differently about that, which is why I'm unsure about this. In fact, I'm more unsure about it today in 2025 than I was in 2013 when I first started talking with Alabama notaries about this step. Back then, I just felt it was overboard, unnecessary, and that there could be some signers who would be uncomfortable leaving such personal information with the notary, not because they were up to no good, but because it is not required by Alabama law. But now that we're in 2025 and I have a better idea about cybercrime and identity theft, I am still reluctant to ask a signer to leave what is considered biometric data in my notary journal. But again, here in Alabama, we're not required to keep a journal. There is nothing in our law that says we can't keep a journal and that we can't ask for this information. So you'll need to decide for yourself as a notary if you are comfortable doing that. I'll say more about thumbprints later in another video. Number 13, the notary fee. Professor Closen recommends that we record the state-approved notary fee amount that we collected. And if no fee was collected from the signer, we should indicate that as well. This shows to the courts, when needed, that we are not charging more than we should be for notarial acts. I am starting to do that more now than before. And I think it's because more times than not, my appointments include more than notarizations. Most of the time, there are apostilles involved, travel involved, remote fees involved, and I was afraid to give the impression in my journal that I was overcharging. Now, I do issue receipts that break out those fees, but I am going to start trying to record at least the notarial act fee amount. And then finally, number 14, again, these all come from Professor Closen's Notary Best Practices book. The other information section, almost every journal has a section for the notary to make any notes he or she deems necessary. And so if you haven't been putting anything in that section, I encourage you to do so. It will go a long way. I've said this before, I'll say it again. The two times I was contacted by lawyers or the court to share what happened at notarizations I perform, thankfully, I had plenty of information documented in the other information section of my journal. It made a huge difference. I'd be interested in hearing from each of you in the comments below. What 2 or 3 things or one thing will you do differently now that you've heard from Professor Closen's recommendations? I'll share the 3 that I'll be doing, will attempt to be doing with you in just a moment. By the way, I use the same journal for in-person notarizations as I do remote ink notarizations. I will put links in the description of places you can go to order your journal. One of the places I am a affiliate. I have an affiliate agreement with them and I do get a commission. But Alabama notaries, you'll probably find that the other links that I get no compensation or commission from will fare better for you. And by all means, shop where it's best for you. That's what's important. All right, so going forward, since I did the audit and the research with Professor Closen's books, I am recording the notary fee, and I am also including where I met the signer, and I have started including the signer's cell phone number. And I'll tell you what, that helped me out a few weeks ago. I met the signer at Starbucks. We got it done. I felt good about it. And lo and behold, the type of notarization was jurat. I needed to administer the oath. And it wasn't until after he left and I was checking my proofreading my journal entry that I realized I forgot to administer the oath. Now, his phone number was already in my cell phone, but if it hadn't been, there would have been no way for me to call him back to the Starbucks. I was so angry because that was the day it was storming. But I realized quickly he hadn't gone far and he agreed to come back. What if he hadn't agreed to return? Then I would have asked him to tell me where he was at and I would have driven to him. Yes, the oath is that important. I know that I've done other videos about the importance of the oath. It's on my channel. Check it out to learn more. I hope you found this helpful. I really encourage you to elevate your notary journal game. It's important. It will help you out. Thanks for watching. I look forward to hearing from you in the comments, and I'll see you in the next video.